Okay, good afternoon, everyone, and welcome to this special webinar. So, my name is Anurag Sabu. So, most of you must be aware of my name, co-founder of FundExpert, and today I have with me Priya, who is our co-host. She is from Goodwill, who is our fulfillment partner for eWill services. So, hi Priya. So nice to see you online. So now we will be starting our session. So we'll be, as we have already mentioned in the message which we have circulated, we'll be covering different aspects of different services which we have now launched on FundExpert. So we will start with first will the eWill services which we have launched in association with Goodwill. So I will now invite Priya to take over and start with that. You, as we have already discussed, all of you are currently on mute. So, but at the end of the session or end of the webinar, you are free to write your question on the chat. We will take all your Q&A on chat, and then, as if time permits, we'll also allow verbal Q&A or to take it forward. Okay, and anyway, the session will continue. We'll have a pretty decent amount of session covering a lot of different points. So I hope all set, and over to Priya to start your introduction about the will and why it is important, and you can share your thing and how they can also do it.
Okay, great. Thanks, Anurag. Hi, everyone. I'm Priya Surya. I'm the founder of Goodwill. We are an online will writing service, and we're currently live in a few different markets, and have served thousands of people create their estate plan, almost entirely online to the extent that the law allows. So I'll go into that in a minute. But essentially, we're very happy to be partnering with FundExpert to bring you this product. And as you are probably well aware, creating a will is a fundamental part of having a sound financial plan. So I hope this is of benefit to your clients. So today we will cover just a few topics, and I will take about 15-20 minutes to just talk through this process, including a demo of the product. I think Anurag has already shared the demo, so if most people have seen it, then I will skip that. But I hope to answer some of your questions in Q&A as well. So first, we'll just go through what Goodwill is very briefly, and then a little bit around, explaining to your clients why it's important to create a will, and the way in which they can approach the process, because it can be a little bit intimidating. It's a hard topic to think about, but it's so much easier to do it when you're healthy and well and when nothing bad has happened than when you wait till it's too late and you're not there to help your family through the process. So I will just go through, and feel free to post questions on chat, and when we get to Q&A, I'll answer them as well. So yeah, Goodwill is an online, like a digital portal to just where you only have one question per page. You have a few sections which take you through the process of understanding, how, like, what you need to decide in creating a will. It only takes about 15 minutes. If you have a pretty simple understanding of, like, if you have in most cases, but of course some people struggle with some decisions and that could take longer. It can be completed anywhere. It's all hosted in the cloud, in a completely secure Google Cloud server. And it was created by, like, the best legal minds in India. So we consulted a number of legal experts who are expert on this topic of succession planning, and they went through and all the resources that are provided through the platform. And of course, it's very affordable for the user compared to other resources that are available. So how it works is, the user could add their family and wishes in just a few minutes. Then they download the document. So according to the law, the document must be signed in ink by two witnesses. that are, essentially you sign the document and the two witnesses say, yes, I have seen this person sign the document, and they sign as well. And that makes the document now legally valid. So it can be stored somewhere safe, like at home with your important documents, or um, in a similar place where an executor can access that document. So in case something happens, we don't suggest a safe deposit box unless you're sharing that with the executor, because if something happens, your assets could be frozen, and then the executor can't access the will, which is the entire point of having the will in the first place. So this is the basic of how this works. And then it's an online account, so they can log in anytime to make any changes and update the will without having to re-enter all the information again. Um, so that's how it works. So there are lots of reasons to create a will, and I've outlined some of these, and I'll share this presentation with Anurag so that you can go through it in detail. But basically, if you have, different, you may have like a young couple with children, you may have an older person with adult children, or you may have someone who's single but who has parents they're supporting. So there are different situations where different reasons appeal to us. But some of the most important reasons, of course, is that you get to decide who receives your assets, not the courts. By writing a will, you can ensure that your loved ones and the people that you choose are receiving your assets. And of course, if you have minor children, then it's important that you choose who's going to raise that child in case something happens to you and your spouse. Um, that's also very important, and make sure there's some financial resources behind those decisions. And of course, it's a lot faster and a lot cheaper to create a simple will while we are all well and good than to postpone the process till later when it can cost much more to have not created one. So it will make the entire process of probate very prolonged, and your family could like miss assets that you have accumulated, like life insurance or investments or other things, because we just have so many, and maybe we haven't properly documented what we have. And of course, all of this reduces at a time of grief. Like to have this organized is like a big load off of most people's minds. So these are all reasons that, different reasons might appeal to your clients depending on their circumstances. But it's the fundamental thing is that it's a key part of every sound financial plan, and you can emphasize that, and it only takes a few minutes, and it gives you such peace of mind. Once it's done, then it's there, and you don't have to keep thinking that in case something happens, there's no plan in place. So the same reason we would suggest clients to have life insurance, it's very similar when it comes to will writing. You don't expect for something to happen, but if it does, it's there. And in this case, it's very affordable, and you can also change the plan very easily as life circumstances change. So there's two ways to divide an estate. One is very popular, in that we see in like in Bollywood, which is like, maybe you think of your estate as a set of assets, and then you want to give it to particular individuals. So that is like the way we think of the will is like, oh, I'm like the king, and I have all these, things, and I give it to these people. But actually, that's quite a complicated way to create an estate plan, because our assets are always changing. So if we're micromanaging who gets what in a very nuanced way, then when our assets change, we have to keep changing our plan. So I'll get to that in a minute. But that's gifts is one way where you can give a sum of money, valuable items, property, accounts, all of these things to particular people. A second way to do it is a percentage distribution. So where overall you take your estate and you say, 50% goes to my spouse and 50% is divided between my children, or however that makes sense for you. So I'll go through a couple of examples very quickly. So when it comes to percentage distribution, we need to understand what is the pie, what is the overall percentages of, right? So we have all of our assets. So that's properties, savings, investments, all other belongings. This is all part of our complete assets. So out of that, you subtract debts, gifts, nominations, other things that have already been earmarked, and the remaining, so like estate expenses, funeral costs, exactly. The remaining is the residuary estate. So I'll go through this idea one more time. So when you're assigning a percentage, it's the percentage of this residuary estate that you're assigning. So what that means is that you have all of the assets, and then again, you have these, essentially joint accounts, nominated accounts. They're directly given out of the estate as soon as something happens. Gifts are taken out of the estate as part of the will process. And then any taxes, expenses, debts, those are also paid out before the estate, the percentage distribution happens. So then, sorry, I seem to have gone to another screen. Can you guys still see?
No, we can't see your application. I think.
Okay, let me.
Yeah, you can
I
just.
granted someone permission to do something, and then it. Okay,
So.
1 second.
Uh,
Let me go back.
yeah. Just maybe stop share and then reshare. That will be because I think you granted some permission to do something. So just stop the share on the bottom. Stop sharing on the top. It will be there. Stop share, and then reshare yours.
Got it. Okay. Okay. There I go. Okay, so let's say a will writer has three, adult children and a spouse, and he wishes to give property to the spouse, maybe the family home, and then divide the rest between the spouse and the three children. So basically, you can suggest, okay, the way you would do it on the app is you gift the property to the spouse as a gift, and then you divide the residuary estate between all four heirs, right? So your spouse and your three children. So that is the way that you would go about suggesting that. The second is, let's say the will writer has two adult children, no spouse, complex assets. So, and he wishes to divide this equally. If he goes around, if he says, oh, I'm going to give this cash to this person and this property to this person, he's trying to equalize. That's a lot of wasted effort, and it can actually backfire because assets are always changing. And maybe there are some circumstances, where medical costs drain a certain account, and he doesn't actually, the wishes don't end up being fulfilled. So rather an easier way to do that is to actually approach and say, give the residuary estate 50% each to each of your children. And then, when the estate is being settled, they can divide that as possible, as in the easiest way possible at the time. So these are things we can suggest to clients because some people have a plan in mind. But if they don't, it's valuable to help them come up with an easy plan. And an easy plan means one that's easy to maintain, even if our assets are changing all the time. So you minimize large gifts. Of course, you can give any number of gifts. The platform allows for unlimited gifts of like jewelry or sentimental items, anything really that you wish. But keep the large picture in mind. So distribute percentage of the estate. And these decisions, I think, can really weigh on people because they think they're like a final decision, and it's hard to decide and it's hard to move forward. But just, it's good to remind them that it's just a temporary decision that they need to make, and then they can always change the plan in the next iteration of the will. So every few years, they can consider revising the will if they choose. Um, and this is the mantra: keep things simple, because assets are always changing, and the point of the will is to avoid confusion and conflict. So if you use percentage distribution for the vast majority, that will prevent, but at the same time you respect the will writers decisions. There may be gifts that they want to do that they feel strongly about, in which case the platform supports that. But these are just things to remind them about. And then, of course, make nominations whenever possible, because when you have a direct nomination with, the financial institution, then the transfer happens immediately, or when as soon as they can process that, rather than going through the probate process. Um, so yeah, the final advice is to complete the will document first, because it only takes a few minutes. And then, you have access to the platform for 30 days to make any changes, additions. List of assets can be completed during that period, either, on the platform or in a separate spreadsheet. But yeah, that's this is the preview of just how to go about approaching this process. Um, and of course, we have all the details on the website about our data security, etc. So what I'll do is I can go to the demo now, if that's something that maybe I can get a sense of how many people have seen the demo, would like to.
We have distributed just yesterday and today, so I guess you can please go ahead with the demo. So it will be
Oh,
interesting for them.
okay, great. So let me stop sharing and reshare. Okay. So when you come through the FundExpert iframe, the portal, you will land here, which is like a blank canvas for creating a new will. And I'll just walk you through how this works. So let's say we're creating a new will for this person. Marital status, married. And you can add additional ID information, like let's say an Aadhaar number. So you can add children. This child was born in 2019. Can also add other information here if you like, but birth date is sufficient for children under 21. So let's say choose an address. Then it's done. So this is the main dashboard, and these are the sections that need to be completed. The first is you and your family. Next is guardians for children. Next is executor. After that, we do the percentage distribution. And then these are optional. So if you want to give gifts or specify assets. So already the will is 25% complete. So let's say we add guardians. You like, and every page includes some advice or explanation about that particular decision. So here it's asking me if I want the spouse to be the main guardian, and then I can choose a if I say it's a brother, I can add additional information, such as passport number. So this is gives some advice about how to choose your executor. So let's say I choose my spouse, and then I choose my brother as backup executor, and I'm done. Percentage distribution. This is essentially giving you the explanation of the residuary estate, which I just explained. So any account without a nomination, any properties, valuables, belongings, these are all part of the overall estate. But if you have accounts where you've made nominations, insurance policies, joint bank accounts, these are already earmarked for that person or beneficiaries that you've already signal to the institution. So they're not included in your overall estate. Um, so, so I can give 100% to the spouse, or I can say no, and then say, okay, I want to split it between these two people, or add more people. And I want to do 70%, 30%. Yes, I'll choose backup beneficiaries, choose my children, choose my spouse. So this is in case something happens to the beneficiary, who should it go to? Um, so, you can skip gifts entirely. I'll just show you the section very quickly. So you can leave a cash gift, an item, collection of items. So that means, let's say all your jewelry versus one piece of jewelry. Um, Vehicles, properties, financial accounts. So any of these can qualify, but let's say we want to give, like 1 lakh rupees to, like, and this is my cousin, and I want to, provide some ID. Okay, and then I can say this is, for your XYZ, like your charity or whatever it is, that if there's a message or instruction about that gift, you can choose it here. That's an example, but anything like a property would be, a residential, commercial land or other. So if I want to give a residential property, I say um, where that property is located, address, etc. And then is it a joint property? What's the estimate value? And then I can add the beneficiary to that, and that would become another gift. So those are some examples. With financial accounts, you could give any of these. But of course, make sure there's no conflict between a nomination and a gift in the will. If you've made a nomination to someone, you can make the same gift in your will to just enforce that, or just leave it out entirely. Okay, so this is this section. We'll continue. So we can, one last thing to do, which is add assets. I'll just show you the section. So this is what a list of assets looks like. So assets that are under your sole name, and then assets that are nominations or joint ownership. So it divides that in those two sections. And it includes all of these categories. So these can be, these can be added. So what's the name of the institution and the policy number? So let's say um, something like this. And then it's what kind of insurance policy is it, maturity, face value, etc. Similarly for all the sections. So anyway, back to the menu. Now we will preview our will. And this is what the download will look like. It will provide instructions, which is to print the will, to review it, make sure you understand it, ask any questions, and then to choose two witnesses over 18 years of age who are not a direct beneficiary in the will to actually sign you after they've seen you sign the will, they sign the will, and then you store the will in a safe place. And then we have some additional instructions like, if you get married after creating a will, it's automatically revoked. There's other things that you can read here, but basically, these are things that a user, like a client, should keep in mind. And then we give some registration instructions. So registration is purely optional, where you take the will to a sub-registrar and get it registered. But it is possible. So if they expect there to be a lot of family conflict, it's good to get it registered. But it means that every time you update the will, you have to get the updated will registered. So that's quite important. And then this is the actual text of the document, and they can see the first couple of pages. And of course, as you guys are coming through FundExpert, you'll be able to see the entire thing and then download the will by clicking the download will button. And yeah, so this is, they'll see the signature page, the list of assets, whatever has been already filled, and the personal gift messages as well. So yeah, this is this part of of the presentation. I hope I didn't take too long, but welcome any questions.
Great, Priya. Thanks. It's a great presentation. So now I'll just take on the questions. I'll read them up, okay,
Okay.
as they come, and then we will answer. So, मिस्टर सो आई रीड आउट द क्वेश्चंस. तो आप अपने क्वेश्चन हिंदी में भी पूछ सकते हैं, मैं आंसर कर दूंगा, क्योंकि इवन द प्रिया मे नॉट आंसर, आई विल आंसर इट फॉर यू. तो यू आर फ्री टू आस्क योर क्वेश्चंस अगर आपको किसी भी क्वेश्चंस है, और ऐसे भी मैं दिस वेबिनार में कंटिन्यू, सो आई जस्ट इमीडिएटली टेक क्वेश्चंस रिलेटेड टू द विल. So, like Suraj, Mr. Suraj Jatwani is a question. Can we change the terms conditions? Yes, you can change the term condition. You have a 30 days period to modify your will before you take the final printout. Once you have finalized the will is now finalized and frozen. It is like frozen in time. And then in future, suppose you want to modify it later, like I am, it is mentioned, you will have to take another token, and then you can now then use it. It's like you are again enabling one more token for the client, and then the client can make changes and download the new bill again from the date of exercise of the new token. Again, it will be 30 days validity for you. Okay, so Santosh Karthik has next. So Priya, I'm sorry, I'm answering some questions which are more like straightforward. The one which will be
Yeah,
for you, I'll bring it to you. Okay.
sure.
And if anything you want to add, you can tell me. So Santosh Karthik has next question, Priya. What happens when someone challenges the will?
So anyone is under, um, like anyone can challenge a will, just like, it's a free country. But really, what matters is whether they would be successful in challenging a will. So a lawyer will only take your case if they think you might be successful in successfully challenging the will. And the most important part of that is to make sure that the witnessing and the signing of the will was done properly, that the witness was properly identified, that there are two witnesses who are not benefiting from the will, that they're neutral witnesses. And if that process is done correctly, and in addition, if registration is done, that's even more proof. But that is the basic ground for contestation. To say that someone didn't actually, it wasn't someone's actual wish to create this will and that this was coerced or whatever, but that's all based on the witnessing process. In terms of the actual text of the document, it directly reflects the wishes that you outline um, in the will itself, in the application itself. So anything that you say about percentages or who should get what, who should be the guardian, who should be the executor, that's just translated into legal language that's acceptable and conventional in India. So there's nothing different that it says than what you have already decided within the application. So there's nothing to contest there. If the witnessing is done properly, then the will is legally valid. So we've done everything possible in that process to ensure that no that wills cannot be contested successfully.
Thanks, Priya, for the bit. And I'll just, in line with the same question, you also partially answered the next question. Like Suraj Jetwani said, that can I write my terms conditions? So it's very simple. The what the will does is with the conventional language used in India, the software automatically converts all the your requirement of term condition into the actual legal wording required for the will. So whatever terms condition want, if you just write it yourself, it may be legally invalid. So you have to choose one of the section because you will be writing it in relation to one of these sections only. There are all the possible things which you want to write in a will is already covered in the software of generating the will. So you just choose your section and assign whatever you want to do. The will automatically write in the legally appropriate language, right, Priya? So you don't
That's
have
right.
to specify any term condition because anything you write of your own will which is not legally valid will be contestable or could make something wrong. So here that is all covered in the creation of the will process itself. So whatever term condition you can think of, it is already being think. And if you can come out with some new thought, I'm sure Priya and team will be happy to understand what else is missing in that process because virtually they seem to have covered in the entire spectrum of what can somebody can think of in a will, right? Yeah.
That's right. Yes. And if there's more complexity, let's say someone has like a business, you can leave a business as a gift in a very simple way through the will. But if you want to really like go into it deep and you want to say like this is how the share should be divided, this that gets into a very complex territory. So you have two choices. You can take this document and then get it modified by a lawyer, or you can go to a lawyer independently, but it would be much more expensive and tedious process. So we've made the will as thorough as possible for the vast majority of people. But there are cases where if it's very complex, they may need to seek legal like a legal advisor or lawyer to actually like spell out things like business inheritance. So do keep that in mind. But yes, within reason, we've done everything. We've done a lot, and we're constantly adding new things as well. So we're completely open to feedback.
Fine. And then I go to Santosh Karthik who has a question. How does this work in case of inherited wealth?
Yes. So this is something we address in the keep in mind section. So if you have an ancestral property, right, property which is inherited up to 4 generations before, then you cannot give away that property through a will. You need to go to a lawyer to first partition the property, and then you can give away your share under the will. So this is something that we mention in the keep in mind section. for the clients, and it's something that you can also advise your clients that first they need to go partition the property before they can give it away in the will.
Yeah. So Santosh, I think that answers the question. It's more like a legal thing. If you are inheriting wealth, you're supposed to legally partition it to the respective owners. And if you have inherited your share, you are free to will it away the way you want your share.
Yes.
And because we come to the next question, Vikas. So his question is, what are the benefits of registering the will? I think you covered it, but maybe you can say a few words.
Yeah, so benefits, of course, if you really expect your family to be, some families, there's just like a lot of conflict, and there's conflict, especially around property. So you want to double make sure that there's no room for contesting, and that this has been solid. Then it's worthwhile to register the will, but it's completely optional. That is, like, you can sign the will in the way that I've described, and it is legally valid. But registration gives it that extra security. But it does mean you have to update the registration every time you update the will. So do keep that in mind.
Yeah, and so that answers the next question also, Priya, of Dharmendra Vyas. He says, "Can is registration compulsory?" No, registration is not compulsory for most purpose. So I'll tell you, for 90% of the people, just downloading the will, taking signature to signature, and keeping in a safe place is good enough. Because for most people, they are having very simple family structure where there won't be likely to be, like, people will not try to create a defraud or things like that which you don't anticipate. It's more an instrument to help you manage the transmission of other assets which will happen. So in that case, when you don't foresee that, you have a simple nuclear kind of families and structure, you don't need that. But when you have a large joint family kind of structure and you expect a lot of things to happen, then, like, this person can do malified, or you want to create a bona fide copy which somebody can verify, you think there is a lot of possibilities of changing because your family structure is very complex and everybody is connected or something like that, then you should get it registered. And then what will happen, a registration basically makes available a copy with the sub registrar, which can be accessed and which court can rely on when there is a dispute to decide which is the right one. But by default, for most people, when they don't have any will of any kind, this is the first step, is to create a will and take signature, keep it, and that is good enough. A legally accepted will be accepted in any place, as long as nobody is trying to raise a dispute on the thing, which is very unlikely to happen in most of the cases, because most of the cases you just need to present it to make sure that transmission documents happen and court can recognize it, this is the last will. And that they will use that will to make sure that other transmission assets, that process becomes very simple. In absence of that will, it's a very very complicated process. You can ask anyone who handles estate management. In absence of will, the thing goes pretty haywire to manage each and every transmission of asset, because virtually you will be running from post to pillar in a time when, like Priya said, presentation, when you don't want to deal with all that, when somebody is already dealing with tragedy, you can't impose another one of this kind of thing, to deal with potential hassles of without having a will. So having a creation of will is very simple. Create it, print it, download it, and sign it and keep it. It's very simple. That's all it takes. It don't have to go and register elsewhere unless you anticipate a dispute in certain situations, which could be a very specific use case of one of okay. If you are handling nuclear, if you are advising clients who are nuclear families, you will not find any issues like that. But if you are handling clients which live in joint families, say very huge kind of families, and the client himself very very apprehension, it's a very simple sub registration. Very simple registration process is simple, but like I said, once he creates, it will be need to be updated every time you need to do. You have to go to sub registrar and get it updated every time. That's the additional. Okay, so that I think just added to clarify that point. And Rajendra, yeah, what are the charges? So I will come to that. The charges, what you will charge the customer, and all that, how much you will pay. All that I will cover it post. Once we have done with the will and technical aspect related to will, I'll cover all those points. Okay. So how will this will get activated to you? How will you assign to the clients? All that I'll cover it. Okay. So I guess, yeah. So what value add a financial advisor? Oh yeah, that's what you're doing. See,
In Yeah, I can also address this question because we have a lot of financial advisors who come us to partner with us on the platform. The main, there are a few different things. One is when you provide holistic financial advice, creating a will is part of that process. So if a client feels that, you're not just, selling them certain products, you're also like, providing them like a holistic solution. And, Anurag, you may be able to speak more to that. The second thing is that as you're helping them, consolidate their assets and making sure that all of that is recorded in one place, that is a great way to continue that rapport that you've built with the client, and share that knowledge, and be on the same page as far as all of their assets are concerned. So those are two things that why financial advisors come to us. But Anurag, I leave it to you to continue that answer if there's more.
Yeah, sure. And exactly, Priya has got those points right. And exactly, and the same reason, because when you are advising customers, you are explaining them the financial products, they are basically, you are creating him build a future wealth. And you also want that future, whatever he's creating, should be then subsequently go on to the right person. So you need to create will. But like you, if you can go and ask most of your clients, just take a survey, how many have created a will, and you will get a very pathetic, very low single digit percentage, surprising to you that despite so much effort and time they've created to build all this wealth, they have hardly spent any time thinking about creating that most important document, which will be required post any tragedy or any kind of these kind of circumstances. So the moment you even tell them to make a will, you have started value adding that time itself. And during the value add of the will is, see, this process which you're seeing, since you have an access, thanks to the FundExpert, the way we work, you will be able to guide him to in the will making process. So that's a value add which you do, which when you see this process and when you do this on his app or on his web on FundExpert and you help him to create, you will be able to guide him on different questions, how you can answer it, how he can answer it, all that. So that additional value add, you will be able to spend time with it. And like Vidya said, the more you do that kind of work with him, understanding and helping him to account for that, more you develop a close rapport with him. And that rapport always is useful when you are counseling him for so many different products, which are available under the basket, financial baskets. Okay, so coming to that, John has next question. How many times can I change before taking print? You can change n number of times. You have a 30 days period. There's no limitations on number of times you can change before you take the final. Right, Priya?
That's right.
So you can change any number. I think, yeah. So Dharmendra says, what is the difference between nominee and legal heir? So
Yes.
you want me to answer? You want like to answer?
Um, I either way, but basically a nominee is in the sense of how we are defining it to give it a differentiation. Nominations are made with the financial institutions, where you specify, okay, this is my spouse. I'm giving her, in case something happens to me, this account should go to her, and that's a nomination. And a beneficiary is someone in the will who will receive your assets. So similarly, you're making, this is my spouse and she receives like 80% of my assets. That is a beneficiary. So that's the term that is used. A legal heir is could be a beneficiary. So you can actually name your legal heir, who is your spouse, as a beneficiary. But in the strict legal sense, it means, according to the law, this is a person who will receive your assets in case you don't have a will. They will automatically receive something based on the formula that the government has, based on your religion and civil code. So that I wouldn't confuse everyone too much, but just nominations, think of them as things you make with your banks and your insurance companies and your investment accounts. And beneficiaries are who you can outline in your will. And legal heirs are just, your heir, which according to the law, who will receive some of your estate or all of your estate
Yeah, so
based on.
I will explain this point in more probably the way he was trying to understand. So here,
Okay.
nominees, what like you make with different institutions, and as you can go and check with those institutions, nominee only allows is a actually a given information given to a financial institution to whom he has to hand over the money in case of that happens, who will handle it further. it doesn't mean that they nominees become the owners. Nominees in Indian context don't become owners. They only become like a trustees. They will take, so the financial institution, his responsibility ends when they give it to nominee, so that their legal responsibility is over. Otherwise they will be all the time worried whether I gave it to the right person or not. So nominee makes their job easy, and it makes the getting money and control of those assets from those financial institution easy. So you should do nomination so that nominee gets control of that asset. Doesn't mean he owns it, because after he gets control of the asset, he has to consult the will, and who is the legal heirs defined in the will, they will be given those assets actually. So the legal heirs are the real beneficiaries. Nominees are just people who are assigned by you for getting control, so that they can approach to those institutions in your absence, in whoever the person who is nominated, and get control over the assets. And with a small, with, because once you are nominated for finance institution, it becomes easy. You present your proof of of a nominee, as who are you, as your ID address proof, and he will simply hand over and say I am done with, because you are nominated, so my job becomes easy. So nomination is required so that you can easily get control over the assets from the financial institution, the people, for your so that it can go to them. And then once the nominee receives it, he has to consult the legal heir. So that's why you have to create a will to do that. Most people think nominee and legal are same, and actually in most cases they are same. Like most of people think, anyway, after me my wife will do it. So his nominated wife is not put any will. After a will, because of nominee, wife gets the money, and now nobody is questioning who is going to take how much. So generally they take care of the entire wealth the way they want, and just do it. And since nobody is questioning, it is fine. But tomorrow somebody questions, then they will say where is the will, because nominee will not be considered as a will. The will be, whatever is written in the will be considered as the legal heir. So that's why you need to create a will, so that tomorrow, suppose because you have nominated your wife, and she gets the asset, and tomorrow your child son wants to claim it, and he can say, so what, she is nominee, but I am there's no will, and I am equal legal heir, so give that money to me. And he can take your money from your wife at her old age also, for by fighting it, and he will win also, because he is legal heir, because you have not defined it. And your son and your wife are both legal heirs, so both will have to divide it. So if you really think that, okay, because I put a joint, I put nominee my wife, automatically she will only get control of it. She may not retain it, because of somebody can fight it. But if you put in the will that this will go to my wife, then 100% that asset will go to your wife. Is that clear? I think, Priya, you got the point what I was trying to say.
Yes.
So that's
Yes.
the difference. That's why you have to create a will. Just creating nominee is like first half of the story. Creating will is the second half of the story. So both story needs to be completed. Then only real succession planning is complete. So succession planning, most of you thought, I have made all my clients nominate in all the accounts whatever they've invested. You've only done one half of the story. That is definitely needed, but you need to do the second half by putting a will, because without the will, other people who are related to can tomorrow claim that this money is also to be given to me. Just because she's nominee doesn't mean she owns it. So that time, if you don't want that to happen, then make sure you have put a will in place. It means your client, whoever. Okay. So now that questions, this is very important distinction and very
You can
important.
reinforce this. So if you nominated your spouse for a certain account, you can reinforce it in your wills in
Yeah,
the gift section
you have
with that
to.
financial account.
We are saying we have to, because if you don't do it, then you are leaving it to that somebody should not tomorrow fight it, and then it's fine. But if somebody tomorrow claims it, then she will have to fight it, because without will, she will not be able to just say I'm nominee and able to take it. If the other person is somehow related to you, then as per the law, whoever is related to can entitled to, can claim, then they will claim. Like like a process between wife and son, which can happen in the old age, between when the father is not there, then the wife and the son are fighting, and these things do happen in today's life. So if you don't want that to happen, then this document will help. Now Santosh Karthik's question: how do you convince the process, this client process legal? There's no government document validate. It's a legal process. Go and ask anyone. If you it's a You just search on Google. When you create a will, a standard will which signed by two witnesses is automatically legal. It's a defined in the law. It's there in the Google. You don't have to put it. It's a known process. Just search it, and that's all will is. Yeah, if you have created a will,
I'll
you have
just
signed.
add
Yeah, sure. Yeah.
that this was created based on the Indian Succession Act of 1925 and the laws governing Hindus, Christians, Buddhists, Sikh, Jain, and Parsi succession. So each of those is defined, and we've combed through all of those in partnership with legal experts in India to come up with the best document possible to reflect these wishes that are tailored to the individual's particular circumstance. So everything has been painstakingly done because this is going to be serving thousands of people. It's going to have a huge impact. Probably a lot more. But so we just have taken every step possible to make it very painstaking. And the other thing is, Muslims cannot use goodwill. So just please bear that in mind that it's a different set of laws that governs their succession. So if you have any Muslim clients, they cannot use goodwill to create a will.
So basically, the legal document which makes the process of will valid is Indian Succession Act 1925. That was the original, and everything comes from that. So if you go and check, and that is the document which says that when you create a will with two signed signature, it's a valid document. So it is by default valid. It is the definition of a valid will. Okay, so that will take. And Santosh Karthik had this question. So will supersede nomination? Yes, will supersede nomination, because nomination is a process. Because without, see, you don't expect each financial institution to go and check each will. Arey, kisko, what I have to give to whom. They will go simple. You have nominated. I have a nomination record. I have a nomination signed form. And recently, you would have seen. Recently, for every demat, for everything, they said if you don't have a nomination, they can freeze it because they want everything to be clear. So nomination is something which you do for everything, so that there is a record. What financial institution has to do if somebody says that person is dead, now give that money. Then say, okay, who is nominated? And he'll give it to the nominee. He'll take the proof of death, obviously, the proof of death, whatever, that certificate or something, and the proof of ID of the next person. And then financial institution is free from any burden of tomorrow checking whether it should be equally divided or more divided. As per nomination, whatever is nominee divided, he will divide and give it, or a single nomination, multi nomination, all things are possible. But they are very clear that is finishing of their responsibility. Just because you got your mutual fund divided into 30, 30, 40 as per nomination doesn't mean your will is divided. Tomorrow they can say why it was 30, 30, 40. We are all equal shareholders. We should all get 33. So your nomination percentage doesn't make that. They can't claim it later. If tomorrow they think this money is too much used, why I'm not getting so much share, why I was nominated, and they fight it, they can fight it. So if you don't want people to fight after the person is not there, then create a will, because nomination will not end your fighting. Only the will. So create a will to end that kind of situation. Now, what is probate? Probate is, Priya, you can explain. So what is a probate?
Sure. So probate is the process that happens after someone passes away, where basically they take the death certificate and the will that was written, and they say, okay, this person has been chosen as or nominated as executor. So they will now have the responsibility to distribute the estate according to the wishes in the will. So that process, that whole process is called probate. So what happens is usually the executor who's been nominated will take the help of a lawyer to essentially submit the documents to the court to distribute the assets. So then the court will issue a court order, which you can take to the different financial institutions where there has been no nomination made, to the wherever properties are being held, and you can actually get those properties to be distributed to the beneficiaries according to the will. So to do all of that, you need that court order, and that process of obtaining that order is called probate.
Yeah.
Is that clear?
Yeah, absolutely clear. So basically, in order to convert your will to an executable order for a financial institution who does not have any nomination, you need a probate, and probate is the order passed by the court. When you file a will with that and say issue a probate order, so that we can go to the relevant institutions and give this probate order as a proof of how the asset has to be divided, and then based on the probate they will transfer it to me. So like a demat account who does not have nomination, how will you go to that financial institution and say, now give all the shares to me? He's saying there are 10,000 Infosys shares. How can I just give it to you like that? So you have to go give the will order to court saying I am the legal owner, or these are the three legal owners, or there's only sole legal owner, whatever. And then take that probate order, give it, and then the IDs of respective people will be given, their respective demat details will be given, and then that financial institution will divide that in that ratio or whatever, and hand over the or transfer the securities in that. So basically securities will move from the, based on the demat, based on the probate, it will move from the deceased demat account to the beneficiary's demat account in the ratio defined in the probate. So all that process when you have to do. So but if you are done nomination, then you actually will not need probate. So probate is a step you need to be taken. If you have not done nomination, then you will need, because if nomination is there, then the simple thing is ask the nominee to collect it and then divide as per the will, and then you will not need to go to court and all that. But people don't do nomination and people don't do will, and then they get into problem. So get them to nominate and get them to make a will, and you don't have to run around with any lawyers or any court anywhere. Otherwise, all this effort at the time of when you're not supposed to do, all that will be required. Okay, so Santosh Kumar has a question: how to ensure sound mind was there during will creation? I think witnesses are required, but exactly for the same reason. Priya, your thoughts?
Yeah. So basically, being sound mind means, you have someone who has an understanding of their own actions, and they have, a reasonable knowledge of their family, their possessions, and their surroundings. So they are able to, that they're coherent, that they're not senile. So as a witness, you're saying that I'm witnessing this person signing the will. They haven't been coerced, and they know what they're doing. So that's the definition, by law.
Right. So then Ravi Kopp has a question: who will be the scribe of this document? I think the person who is signing it, the person who is generating it, scribe, unless there's a different term, yeah, will be
Maybe
will
they
go
can
the scribe.
explain what they mean by scribe, like the will writer, or yeah, it's
Yeah,
not
I think
clear.
who is the author of this document, like that. I think scribe.
Okay. It's from the voice of the will writer. So the entire document is the will writer's statement
Yeah.
of what they want.
It's the
Yes.
last will of that person. Think like that. So it's his will. He is writing. He is the authoring it, like that. On. So John says, is an option to add religion in the software, like between Hindu and Christian or something like that. It's defined somewhere in the software.
Yes. So actually, if you go through from our website, india.makegoodwill.com, it's the first question that pops up. It's like a qualifier to see whether you can use the portal. So if you choose Muslim there, you will not, it will say that, the laws are different and you cannot use this platform to create a will. But in the flow that we have with FundExpert, it goes directly in. So it is up to you to make sure that the person is
Question is not
not.
that. Question is that, do you have to define a religion, like you are Hindu or Christian? No, forget Muslim. Cannot do it, but others, between others, like, do they have to define it? I don't do. They have to say I'm of
You
this
don't
religion.
have to define, according to the, you don't have to define it as a requirement.
Yeah.
So
So it's
we
not a
we have not
requirement to
included.
be defined that I belong to this religion, kind of. So you don't have
Yes.
to define. Okay, and he's saying, do any code stamp is required? Dharmin, that Vyas ji, that was the same question what other people. Registration is code stamping. When you register, na, it gets stamped. So that's one optional. That's what we are saying. When you go to sub registrar na, and you give a copy, that's where he stamps it. That stamping is a proof. He'll give a stamped copy to you, one copy will be with him. He will ask you to bring two copies of that. So that's what will happen. So that's how. But that is not a mandatory process. It's an optional process. Like we said, na, registration, that is an optional process. It's like It's like when you buy a property, it's a compulsory process. But when you do a will, it's an optional process. So not necessarily every process needs to be registered. In this case, it's not optional, so people can just make a simple will and sign it and keep it in house, and that's good enough. Just keep it in a safe place, and that's what we say. But only if you, like I discussed earlier, you have a very complicated family situation and things like that. You have a stepdaughter and stepwife and all kind of stuff. Then probably you need to get all registration done. Okay. Otherwise, normal families, like most of the clients you will find, you may not need a registration. Okay, that you can always discuss the client and get it done. It's a thing. It's not a big thing. Just walk into two copies of this properly drafted two signature, and just they will stamp it and give it, because it's just a copy they're keeping and one copy they're giving, and they will charge whatever stamp duty charges applicable in that state, because it's a state. Okay, so that's all. So I guess all the, yeah, will appreciate how all of us will become. Maybe I'll do a separate session on how different things is required, but maybe it's more useful for your client or something. So maybe we can, this can be done separately if required. But basically, it's something which is can be easily explained to anyone. I know how it can happen, because so many examples we gave and quoted. You can easily give an example of how things will become painful. So yeah, but if we already covered enough, and if you look at whatever we had discussion, but it's fine. So, what is the Sanmukh? Your question is not clear. Executor and witness, not beneficiary. Executor is the person who is executing the will. Witness is the person who is signing the will, and beneficiary is the person who is receiving the assets in the will. So there are three different people, right?
Right, and the witness cannot be a beneficiary. That's like the most important thing. You cannot benefit from the will. You cannot be the spouse of a beneficiary. It has to be someone neutral. So if they're receiving a gift or a percentage, you cannot have them be a witness to the will. So just keep that in mind. That's one of the most important rules. Other than that, an executor can be a beneficiary. So you give it, your brother is your beneficiary, but he's also your executor. That's all fine. And that's explained in the flow.
Okay. So I'll just take one more question because I'm not very sure what is the question. Next one may not have bad mandate probate about signed will. Probate is a process which you get from court once you wrote the will. That post you need to get a probate order from the court to go to that. I think there is the question is little confused. It's not that. And what you can saying, if any uneducated people get done here, then you can't tell he's the scribe. No, he can say because when he printed, he can say I dictated this and the people typed it and then I signed it. But if you think because it's here it is printed in English and you say that it is not his word and he should have written Hindi, well that because he said this is an English translation of that or something because he has signed and he's got two witnesses. So those two witnesses will whether this will was understood or not. Because a lot of people who get the will drafted, not necessarily everybody has to sign in their local language only to get it. So he can say that he understands this much. Because how will you prove that he does not understand a written English? Just because he has not finished class 10. There are a lot of people who might not have finished class 10 but can speak English and write English. So I don't think so. How will you prove post his death that he does not know English? That and if you want to fight it out and if you think it is then get it that registration done. If you think there are other people who will say this will is not genuine, he is not educated, and they will fight it and there will be fighting which will happen, they will claim their assets and you will use this as a principle, get it registered in stamp in the court, in the sub registrar, get it registered, then this question will nobody will be able to ask this question because there will be two witnesses who said he understood, signed and filed. Okay, so I'll go to the last question before we end now.
Yeah, and just the one quick addition is that your clients can use Google Translate extension to read the application in any language. So whether it's Malayalam or Tamil or Kannada or Hindi, they can do that. But the actual document will be in English. But it's very simple language. Hopefully, most people can understand, or you can help explain it to them. But yeah, that's an accessibility thing I want to add.
Okay, great. That was that's a new point, and thanks for that, Priya. That will help people to understand and explain. Yeah, because then you create, if you in that case create this thing, create a you can generate a will and do a Google Translate of it, and then if you want to sign that and keep it, and you think that is more legally valid, you can try it out, or you can get it registered and the yeah, Google Translate allows in all languages. You think will Google Translate available in Bengali? Yes, it's available in Bengali. It's available in all languages. So Google Translate. So I guess that will take care of that. Okay, so
There's
you
no,
can so Ravi, so you can
sorry,
get yeah, so you can get it registered in the sub registrar office. Then this will not fail because of that. Because once it is registered there, then it is there will be a witness who has signed and done that. So then it will not be unregistered will, yes, and if there is a dispute possibility to happen, then yes, that's what I'm saying. Why? Because wills will only fail with somebody who tried to dispute it, right? So if you foresee dispute, then do get it registered. I would say that. Yeah, you were wanted to add something, Priya?
yeah, I was just saying there's another question here about any option to pay stamp duty online and authenticate electronically. And this is an important point. According to the law, the estate planning documents cannot be signed digitally. There's no stamp duty involved in creating a will. Even for registration, there's no stamp duty. So you don't need to do it on stamp paper. You can do it on regular. You can do it on regular white paper. But yes, it cannot be signed electronically. It's very important. They have not, some countries have started, but India has not yet started allowing this. So you need to sign it in ink with two witnesses present. Okay.
Okay, so Varun, we are not that modern that much, but India will reach that point somewhere, and when that happens, we'll also give you those kind of facility. So right now, you go straight forward, take a download, put a ink, sign it, keep it. It's a single document. You are going to create one for your life. So I think that much effort can be taken. Okay, thanks for everything. Yes, Somaya, you will get a version of this. We will send. I mentioned if you go back to in the chat, I'll make it available. Okay, I guess thanks a lot, Priya. That concludes your. It was yeah, and much more anticipated. I think a lot of interest from our participants. We can expect a lot of things going forward. And thank you for your presence. And
Thank you so much.
I hope you had a great time. So yeah, so I guess you can leave. So right. So I think now it's time we can take up other things. We had questions like you had questions on the on various things. So I'll take on the presentation now. अब आप पूछ सकते हैं हिंदी इंग्लिश कोई सी लैंग्वेज में आपको जानना है क्योंकि लाइक somebody said she because she had this software is presently working in multiple countries and she is based out of Singapore. This is a it's a software which is working across India because this will is not a it's a universal problem. It's not a India problem. It's not it's everybody has this problem across. But only thing is laws and things change for everywhere. So the software needs to be changed for every region and we are deploying you what is applicable for India. Okay, so use that and it's available through your FundExpert. Now what is the cost of this? So I'll just share my screen. I think I had already circulated that it's now available on that. Most of you would have seen. Those who have not seen, I'll show. So this is a great earning opportunity for all of you because you can see the cost. It's not showing the portal. Yeah, it is showing. If it is not activated in your thing, from tomorrow it will start showing it. I'll just promise you. If you want it very urgently, yes, I can ask RM to take it. You can ask your RM, but it is available on the admin panel. So if you go to our admin panel, I'll just share my screen. Okay, so I am on this is the so it is now corrected and I'll just show you that code. So when you click on that, okay, so you will not get this issue. So now if you click on eWill services, you will get this page where you can see you can read a legally valid, very simple. All these benefits, whatever I've shown you, is already there, and you can now. This is the cost of the will. So what is the cost of the will? If you want to purchase one will token, because one will token is valid, is one for one will you need one will token. So basically, 2,250 plus GST will is the charge. So we'll and then if you purchase 5 will token, it will cost you 750 plus GST. Okay. If you purchase 10 will token, it will cost you only 1250 per GST per token. So your per token amount keep coming down the more number of tokens you buy together. That's how your benefit is. So those you can buy one as a trial and then you can purchase another 10 tokens at this rate. I would suggest that's how I would suggest if you have anything and you can give it. Now these tokens you can assign it to the clients who need it. So when your client go to the portal, they log in. Suppose I'm in demo IFA and I'm logged in, and this is how login is. You'll be able to see my screen. I hope you all are able to hear and see. So here I can search a client. So I can search a client name. Example. I can also search for master clients. Like if he's a head of family, then I should use this. So if I search here, say Vanita, I'll get this client. And if I go to the when I go to the client account, there will be a eWill option which will be enabled. Okay. So it will appear under others. If you click on others, you can see make a will. And if you click on this, it will say give your name, mobile, email, because this is what it will take and you can submit it. Because once you submit it, it becomes your ID. This is your permanent ID for life and this will be created. Okay. Now there are a very important benefit. Your will you will be able to create for 30 days. But remember there is one extra benefit which you are getting is you are getting your acts that will once it is created and preserved. There is always a lifetime validity access under this ID. This will always be available there. So tomorrow, if anybody has any doubt on whether the will which they have is a genuine one, somebody's tampered it, they don't have to, they can just go here and take here, because you can't tamper a will which is created online and saved here after 30 days, because after 30 days it's frozen. So, and every time he has to alter it, he has to take a new token. So there is a record at the advisor level as well as our level, because payment has to come or some token has to be issued. So without knowledge of advisor or knowledge of without making a payment, the customer will not be able to modify will. That means the will, once it's created, becomes a permanent repository. Although an online will not be of legal, because that will not be signed, it will not have witnesses, but it can be used to always use as a reference and as a documentation to compare with the copy of the will they have. That tomorrow if somebody has not erased it or done any changes, they can always do this and figure it out whether it is valid or not. Because if the person had changed will, he would have done some changes here. So that becomes a permanent repository of that. Okay, so now I'll take your question. So this is how you will create a will. Now if you click and submit, if you have not activated will and you have not made the payment, then your client will get a message to contact you to make the payment, because they can't do it. Okay, so when they call you, and you can assign them, you can purchase this will tokens and assign it to them, and you can charge them the fee whatever you feel like you wish to charge for your client. So you can charge the fees whatever you wish to charge for your client. You don't have to worry about it. So you can charge say 5,000 to 7,000 depending your choice and your effort whatever is involved, because you know this client will take so much effort. So you can decide, because you will have to advise and help him to make the will at time. So you can take your call, and sometimes you may feel that no, this client will do on his own and we don't have to charge anything. You know your cost, you can charge him accordingly and make a profit out of this. So this is an additional income generation for you, and every time he will want to change a will, it will again generate an additional income for you. So this becomes a permanent estate planning division for you, where you can generate additional revenues from your from your clients for these kind of services. He does not have to go anywhere else. You don't have to be a lawyer to this, and that. So let me come to questions. Now I'll take your questions. Okay, so now it's clear. You will get this much. You will have to pay so much, and you will get it. And whatever you are paying for the buying for this. So you will get an invoice from us to you for this, having purchased this. You will charge them separately, na, and that money you are directly receiving. Suppose you purchase one bill here. Rana Sahib, I am giving this example. 2,250 plus GST, you paid 2,655, and your client paid you 5,000 rupees. He can Google Pay to you, right? So you collected 5,000 from his. The difference of 2,400, 375 is your profit, is your output. We are giving you at the best prices. You can now charge whatever amount you want, because he will not go and get this amount. So you can charge him whatever amount you feel like. Your payout is directly you are getting from the client. Is it clear? Mr. Rana Sahib, is this clear? He'll ask 5,000 bill and you are not GST registered. So you give him a normal 5,000 bill. Why you have to only generate a bill without GST? Okay. And if you tomorrow you think, no, he wants a GST bill, I will give you a link and I will charge GST to him. Don't worry. And I'll pay you the payout. Is that fine? Your customer wants a GST bill. I take a link from us and collect GST from us. We are GST registered. We will give him a GST bill. And you take the difference from us. Fine, Rana Sahib? Clear? So all possible situations, we have a solution. So don't worry. You go ahead. If client does not want a bill, you charge whatever you want. Client want a GST bill, we will charge and give a bill for you. Don't worry. You come to us and say, give me a link for so much amount for this customer. We will generate a link for the customer. We will give you a validity date also for the link. You can collect that amount. If we collect amount, the entire amount will be, including GST, it will be collected and GST invoice will be generated. Afterwards, you can't come and say GST will not be charged. Okay? So it's your choice. You don't, most of people, you can directly go and collect it. Yes. So you want GST bill, please take. We'll be happy to charge GST. No problem. And we will give a GST invoice also. Fine, Rana Sahib? Your issue taken care of? Thank you, sir. I'll take, because one by one I can finish. So I finish this because in between some other people said. Any expiry date for token? No expiry date for tokens. You buy 10 tokens, you have used only 9. One you have not used for more than 1 year, it's still valid in your account. You can, whenever you have a customer, please use that time only. Or so the tokens are lying in your account, you have taken 10 tokens, you have used 2 tokens for 2 clients, 8 are lying with you. Fine? Is John, your question answered? Because I'm doing person by person, because I'll not take the lot of other questions are coming. So I'm just taking. John, is yours clear? Okay, great. So that question is also clear. What is the validity? GST question also taken care of. Now there are other benefits also. I'll tell you. Yes, it is corrected. Yeah. So no. So what happens? Yeah, Santosh, that was right. I was trying to. I told you because they moved some files and they missed it, because these are all some recently done. We would have come to know anyway, and we would have done that. So that will take it. Now Varun has a question: is the language vetted by legal expert? Yes, this language you didn't probably you missed the initial. She said this was only designed when they discuss with legal experts in different forms. So you if you so it will be, it's a Indian legal expert language. It's an Indian version which you are getting when you're buying through FundExpert. Yes, yes, Rajendra, it's lifetime validity of purchase tokens. So your purchase tokens have lifetime validity. You can use, your money will never lost. You, when you give it to a client, it will get adjusted. It's not refundable. It's not thing. Yeah, you can generate a will. An example, actually in the demo she created a will, and in the end you could see the pages of the documents. So I would suggest, why don't you create a will for yourself? Every person needs to create a will. So speak to any client and easily you can create a will. And you can see in the video, if you have any doubt, in the video in the last section when I share, you can see the will language. It is like first page, second page. Even before the client complete the will, he says one or two pages like that. And in our case, he will see that. So you can see any will created. Obviously, any real will we cannot create. Will, any dummy will, yes, can be created and can be generated. So we can share but obviously it will not have all the real examples of real things. All dummy things can be pulled and one will can be created, so we can share that with you. Okay. So is there a possible to work arrangement where I can seek lawyers who may be empaneled with FundExpert? Okay, so right now uh, we don't see why you need to go to lawyers, but if you think you have such clients that you want us to empanel lawyers for working with your lil, then in that also you please send your your suggestion that this is a service which you will love. You want us to validate good lawyers, with who do not charge probably a reasonable ones, because then it will not happen. We'll have to do a nationwide arrangement, right? One place arrangement will not help, right? So then that is a separate thing of activity which we'll need to figure out how and when we can take it up. But see, at FundExpert, we are here to work out any kind of arrangement which will help you. So please feel free to give your advice and suggestions, and we'll work out how it is possible we can do at our level on a arrangement, because we can't do it for one particular. When we do it, we'll have to create a nationwide network or system to handle it. Okay, so we will figure that out and then. Okay. So is it possible to print the will? Yeah. So I'm saying, like she said, you can actually translate the will online using a Google thing. But finally, when you print a document as that, as a one which is signed, it will be printed out in English. But you can use Google this language translation to see the language in different languages. You can see that. Okay. So so that way, because the language is very very important for legal contest or legal validation. So that's why you will see that even people are different languages, when they sign a will, it is always kind of English, because that tomorrow, no, there is no question or dispute of difference of this thing. So the will, it will be officially in legal language, so that it covers the way it's supposed to cover. But you can, like, keep a translation for knowledge purpose, for your knowledge that this is a translated screenshots of these things, and you can do that. Okay. Loan against mutual fund and shares, yes, that product is under process, so it will get launched. Don't worry, it's probably mostly in this month itself. Okay. So yes, it is available. It's not yet available on client login. From tomorrow it will be available on client login, that button and icon what you're saying. If you want it today available, then my team is making available for select IFAs who wanted to immediately buy the token. So some people have already done that. Then specifically for them, tomorrow we are aiming to make it available in client login for it. But in client login also is available. Unless you purchase the tokens, client will not be able to use anything. Only thing is that he will call you and ask you that I need this service. So okay. Yeah, so a sample eWill, like it is there in the video. If you saw, she generated a will in that, but we will generate one sample, some rough draft we will take, and we will share it somewhere on the admin panel somewhere. We'll share it. Okay. So token price same as goodwill. it is cheap. It is much cheaper than Goodwill. Goodwill charges, you go to the website, it will be 4,000 to 10,000 rupees. We are charging you these kind of prices. So don't worry. It is much cheaper. So thank you, Rajan ji. You liked our initiative. Now I'll come to that. Now you see, we have further benefits also. If you buy these wills from here by doing this online payment, you will have to pay GST. There is no shortcut. I know a lot of you don't like the GST because you are not claiming it, you are not using it. For you, it's additional cost, and most of people don't believe also that GST money is going to be really used for nation building. They think it get misused. So most people hate to pay GST. So we have figured out some solutions also for that, and that's what is my next 5 minutes, 10 minutes I'll take. See, that's why we have initiated a new process. If you see our NPS and SGB, so I wanted to cover that point. We are done with, I think, wills. We have covered most of the points, and if somebody is still not clear, you can always ask me in the session. So now we'll go to NPS. So if I see NPS payouts, they have been revised. I don't know how many people have noticed it. We send message, but this is your now new NPS payout. Okay. So now you can see your NPS payouts is the highest in the industry. There's no service provider who provides more payout than this. Okay. The only thing is, and not only this is the only benefit. Not only you are getting the highest payout, your also client is paying the lowest charges at the same time. So each one of the client, we have given an illustration here that if he opens an account NPS through FundExpert, his contribution charges will be lower than what he'll pay through Carvey, KFintech, HDFC, ICICI, or his account opening charges will be lower than what he'll pay there. You can check this out. So in net effect, a person invests 50,000 and opens a new account, he ends up saving close to 206 rupees because what he is paying here net charge is 560, there he'll end up paying 767. So for an NPS account, which is the new NPS payout, you can see your user saves 206 rupees every time. Now you are saving here, and now there is one thing. These payouts which you are going to get in NPS payouts, these are all subject of inclusive 18% GST. Now what we are trying to do is this NPS payout, if you have to, we have to transfer it to you, then we will have to deduct this 18% GST. So what we have figured out, a very interesting solution is, we will transfer this complete payout without any deduction of GST to your FundExpert e-wallet on the payout day. And once it is transferred, you can use this to pay any services on platform and you don't have to pay GST. So because we realized most of you are getting doubly penalized. On your income, you are paying GST. On your expenditure, you are paying GST. And neither you are claiming either thing and you are doubly penalized. We are trying to save this here. And I'll give you an example. Yesterday, only one client, IFA, already inaugurated this e-wallet services and we did this transaction. And I'll give you his examples and how he managed to save the same services from by doing this. So you use this and you don't have to pay GST on your renewal charges. So because otherwise you pay online and that we will be charging you GST. But if you pay through this wallet, we will not be charging you GST. Okay. Because this will be considered as part of that. Second, any additional any excess of 5,000, you can also draw deduction of TDS, or you can use it to buy. So all those tokens where you are buying for 1250 plus GST, 1750 plus GST, 2250 plus GST, you don't have to pay the GST. That GST will be 18% extra. If you pay from the wallet, you only pay 1250, 2250, 1750. So you save that 18%. Okay, by doing this, by transferring to the wallet. Now, not only you're getting the highest, your client is getting, and you are getting another 18% benefit by saving on to the wallet. Although we have given this option because some people said, no, if I want to take out my entire payout, then we will deduct GST and deduct 5% TDS and then transfer it to your account if you still need that. Now, yesterday only one client exactly made use of this and he saved money. I'll give you a live example of a client. I'll not take the name, but if somebody wants to dispute this, then I will obviously will be very happy to introduce to that IFA or MFD. What he did was he earned 6,000 rupees payout from liquid loans. And from 6,000 rupees payout from liquid loans, last month what he made, we deducted 5% TDS. So we had to pay him 5,700 after TDS. His renewal was due. He had to pay us 5,000 plus GST. So that is 5,900 he had to pay. Now, so he said, I will pay you balance 200 rupees. I said, you don't know. You said, now you see how we'll make difference for you. So he was thinking he will have to pay 200 rupees more because 5,700 he is getting the payout and 5,900, 5,000 plus GST is pay for the software, which is how it should be if we didn't have a wallet, because you are getting paid here and that is separate and that separate are there. What we did was from his 6,000 what he earned in liquid loans, we transfer 5,000 to the e-wallet. and we use that 5,000 to pay for the renewal fee of 5,000. Once he used that 5,000 to pay for the renewal fee, he didn't have to pay 900 rupees GST. Now, how much was left in his e-wallet? He was left with 1,000 rupees in e-wallet. That 1,000 rupees, because it was excess of 5,000, after deduction of 5% TDS, 950 we paid him. So in effect, he got 950, whereas he was thinking he will paying us 200. So he saved 1,150 rupees from GST and TDS, which would both will be a hassle. TDS will be a hassle to later on cover, and GST would be a cost directly. So this has made their life simple and their payouts much better. So basically, not only you are getting the highest NPS, you are using it to buy all these kind of services. You can use it and save further money on that and make your earnings even go higher. But even if you want to take it out, yes, that option is available. You have to pay 5%, 18%, both will deduct and pay out. Same thing facility we have extended to SGB. Most of you who have done SGB, you know that BSc and SC pays SGB, they charge 0.99% and there is inclusive 18% GST. So you end up getting 0.83% or 835%. Here we are giving you 0.85%. Now that is inclusive of 18% GST. But if you get what we are going to do, without deduction of 18% GST, we will transfer this entire 0.85% to your wallet. And then you can use it to pay for the renewal. Again, you will save 18% on that. Second, you can, if any excess above the renewal, you can also draw it for your TDS. Any wallet you can buy from the platform, again save on the GST. So basically, you are getting 0.85% net on all your SGB, and SGB is running right now. From 28, yesterday it has started, it will run, and this offer is valid for that. So you are getting 0.85%, and on that 0.85%, another 18% you are getting. So instead of losing 18%, you are getting 18% on your 0.85%. So that's the great benefit we have built in, and now we have made your NPS and SGB, sir, because it is our own organization. If you think we are a family, it's like we are charging GST to each other for every time. So we just figured out there's a solution. So I figured out, and we can write software to write all this kind of stuff to make it happen the way it should happen legally. So we did that, and we're saving you a lot of money, a lot of credit for you to get, plus increasing your payout to next level altogether. So you don't have to worry all the hassle. And if you have done any transaction BC, you know how much invoice you have to go, when you have to reach for payment. It's a pretty painful process to do all. So now your task is much simpler. It's much easier to track. Everything is available in one place, and you are getting the highest payout. I could not think of anything more which I can create at this point for on these subjects, but I think we have created something very wonderful, and I'm very proud of that. And I hope you all who are using the services also will feel equally happy and proud, and will spread a word around us for taking FundExpert to the next level, so that we can get more and more benefit. And I'll give all this credit to you only. Because of all you guys only, we are able to get all these kind of offers from our fulfillment partners, because you have strengthened FundExpert so much by participating in doing all this purchase and transactions on the platform. So all of you who have been participating in doing this, you are helping us. And same thing if you continue to do for all product services, rest assured you will get the best deal for every product and services on the platform. For example, in liquid loans, if you go directly and dive with liquid loans, you get 0.85%. We give you 1%. That's why we give you 1%, because you are going to FundExpert. The power of coming together as a group is what is helping you all, and it is benefiting for you all. So that's what we are trying to build. We have already done in one product. Now we have done in NPS. Now we have done in SGP. So all this, why do you think these guys are coming and giving this offer, is because we are able to do number of transactions and number of stuff, which is another level which you individually will not be able to do. And you don't have any pressure of doing so many things. You are getting the best deal on your platter in your place. So I hope you will make the best use of all these product and services we are bundling, and rest assured, like we said, more and more are coming on your way, and you will get more and more benefits. And the best benefit, there is no doubt, you do things from here, and there is no place you will get more benefit from here. That much I can guarantee. Because of the power of this, we will be able to negotiate and drive and take it to the next level. You don't have to individually go and argue with these kind of guys, and we will be able to do that all for you. And I'm sure in due course of time, we will virtually do for each and every asset class which you want to deal, and make your life simpler and easier, and which is what you want, and and more benefits for each one of you. Okay, so that's what we are trying to do. That's why I wanted to specially tell this, that see, because of these product services, Because each of these products and services you're going to buy, there will be a charges, there will be GST, and it's a standard thing. But if you are using these services in the platform and you're trying to do, then you will be able to save a lot of money and energy for a lot of things, and you will not have to pay GST. And it's a painful, because I know every one of you end up paying that much, and we have to end up whatever it is. We give you a GST invoice, that money goes to the straightway to the tax invoice, and there's nothing. So if you make us online payment through that, through any kind of online service, and we receive it, we'll be charging you GST for each and every services which you buy on the platform. Use the wallet to do that. Then, Santosh, what is you are worried about cross-selling? You are worried about we cross-selling. We will never cross-sell anything. Don't worry. You have written to me privately, but I am telling you publicly. Why are we creating all this? Because you will go and cross-sell all this stuff to your customer. Why should we cross-sell? If you don't want to cross-sell as NPS, don't cross-sell. Have you ever sent a mail to your customer saying we have NPS service on platform? It's you to cross-sell. It is your customers, and we value that. We have over 3 lakh plus customers on the platform, huge amount of things. We have enough things on our plate to get worried about. That is the last thing we want to do, and go and talk to your customer and cross-sell anything. Okay, that is your customer. Please do and cross-sell. And remember, you don't have to at all be worried about we cross-selling. You should be worried about all other parties who are cross-selling. Your AMCs who are trying to directly sell, your direct funds, your other insurance companies who are trying to sell other things, your other insurance providers. In our case, you can see we are never trying to do. We always choose partners who never cross-sell. We take this understanding. Will you cross-sell? Will you do anything? Otherwise, their service will terminate from the platform. So they are more worried about it, because we don't want any kind of cross-selling. So even though we are dealing with partners like IFL, Religare, none of them dare to cross-sell anything to our customers, because that's very clear that they say keep all of these a FundExpert customer. Tomorrow he will complain, the IFA will complain, this fellow will come and sit on my head. So you don't worry about that. Okay, nobody will ever cross-sell if you are using FundExpert platform. Yes, that's why I'm saying policy would have been, it is not, because people value personal touch. Yes, Rana Sahib, and I know how your customers also value. I've seen the kind of ratings they write about you on the platform. So I know that kind of personal touch you bring to the platform, and that is your value to the service. And we are here to build value to you through the technology power which you need to compete with the policy bazaars of the world or XYZ of the world, who will try to go direct and do whatever. But people value personal touch and guidance service, as an eWill is another such service available on platform. Such services will be available everywhere elsewhere, but but people will not value, people will not know about it. You are the guiding light to most of these people out there in the world. And India is still a very, very underpenetrated, I tell you, in terms of financial advice. You think there are enough financial advisors in India? There are hardly any financial advisors, proper financial advisors in India. Hardly any. Even improper also we don't have. Registered ones I'm talking, AMP registered. We don't have. So there is a huge amount of market and services for each one. Yes, John. So John has finally written, I totally believe you in now about not doing cross-selling. Yes, that is 100% commitment. We will never ever do it. Okay, any message, if any went, someone could go and make mistake or something. But we are very, very open and transparent. We can even directly talk to customer to prove to you, so that ask him, did we do anything? So we are so much clear and transparent with each and every IFA and each every. For us, we treat all of you as equal partners in our business. And we are very clear. If you see our first presentation, which I did 2 years back in BSc, I said it's your touch and our tech. And we continued with it. It's your touch and our tech. So we don't want to do touch with any of your customers. Please touch yourself. Please use all these services and touch them. Reach out to them and give them these services. And your job of delivering these services, doing fulfillment will be easier, because we are backing you in terms of technology and fulfillment. So you don't have to worry. This is another give them these offers and services, and customer will never think about another third place to go. Create an eWill with you, he'll lifetime be a customer with you. You don't have to worry about all, we'll go to another place. It's all about giving service. So if you give them proper service, create that he will do one thing. His like life is bounded to you. Why will even think of going to another place? He's created it. Copy is available here. Once he has created here, I'll tell you one thing. Once he has created here, even if he goes directly to Goodwill, he'll not be able to create account. I didn't add that. Let me add that also. Tomorrow you'll think, oh, he'll know Goodwill. So what? Once his account is created, how will he know Goodwill? When he enters his email ID. The moment then, till that, he does not hear about Goodwill. Even after that, Goodwill, he goes directly to Goodwill, he says, your account is already created. And then he'll end up paying. So there is no way, don't worry. Your customer is totally bound to you. It is connected to you. It's a lifetime bond you are creating. Each of your customer has a unique user ID, and each one of the user ID is connected to you, and you all have a unique user ID. So basically, we are here to create lifetime bonds and business for you, and that's the value we are creating for you. So use this power of software. Okay, what is the full form SGB? Sovereign gold bonds. Sorry, maybe I'll explain this. Yes, Himanshu, you are right. Mr. Rana Sahib also told the same thing. It's the value add by advisor. If you create good value advisor, you will never have any sides of conflicts, and your customers will never leave you. People have enough problem. No, Sanmukh, SGB demat is not necessary. I have told this so many times. Physical demats are physical process is there. This was only 3-4 months back when RBI just for momentary for 1 month processed it. Now physically you can do SGB on FundExpert. There's an option there, physical. No demat is necessary. I just want to double clarify it. Just an SGB, just go there, enter it. It's a very smooth and very easy process compared to. Just do an NEFT RTGS, enter the UTR, enter the quantity, submit it, upload documents, and that is first time. And next time you can keep buying anytime, and you don't have to do it. It's probably the simplest process. Okay, NPS now even online payments were their contribution where you link and pay. Now people have started doing also. In physical, client gets certificate. In physical, not that physical we are talking. It's an online physical. Physical means the mode, non-demat mode. Let me put that. It's not physical of physical world where physical form is filled. It's non-demat. That means you get an online certificate from RBI in mail, but you don't get physical certificate, because then if you go for physical, you are paying 50 gram extra. In FundExpert, we don't charge. The customer gets online price. So it's an online non-demat. Okay, so physical does not mean 5109 price. It's 5059 price. Like I'm talking to the price. It's online price. Yeah, so thanks for telling, because I know people don't ask us and we can't tell how many times we have to tell, but it's an online process. That's why you go and check the price. Now, if you're giving you 5059, it has to be an online process. There is a physical, it's a non-demat mode. The RBI will email the certificate, will not physically print and send across. If RBI has to physically print and send across, it's charging 50 rupees per gram extra. That's physical. You get an online email next week. Once you finish this week, they will process it in 4 or 5 days. They'll send you a mail, and that mail will be a certificate. And RBI has entire because it's online process now. Your bank is there, your everything is there. So on due dates, automatically money gets transferred to you. So demat is an option which is available. You can use demat because a lot of people want. Some people want demat, and some people want physical. You can't sell physical in 5 years between. You have to convert to demat. So even the non-demat also you will have to convert to demat. Physical certificate were physically present or in email present. Still you will have to pay. You have to get it dematted if you want to sell in between, because transfer can only happen through demat. Okay, so that's why people like to buy on demat, so that if they have idea to sell in between. But most people, I don't think, are just doing it like an investment, like a regular investment, because every series they do some amount, some gram. So in that case, when you're not, you can do physical as well, and physically you don't have to. So that's why I'm saying. So it's a tedious process to demat it, because you are trying to sell in between. If you have clients who want to sell in between, open a demat. We are giving free demat opening service also on FundExpert. What is the problem? We give you a promo code. Do you know that FundExpert opens demat free? There's a promo code every month we issue, but only we don't just mail it to everyone. We only send it to IFAs who ask for it, or who ask the RM that I need the promo code, and we give the promo code. The demat opens free, and the annual maintenance is 300 rupees. That's all, and there is no other charges, and you can use it to demat. And the second best advantage, compared to all the brokers in the world, this demat broker will never target your customer for any other product services by mail. Why? Because he knows it's FundExpert. Whereas all others, for them, they are saying I'm giving demat free, first year free. Why? Because then I'll sell all other 10 different services to this guy later. No, your choice. That's why we didn't go with them. But I guess that's your choice, because the other companies, they only are going to make money from other products. Here we are not. This guy never sends a mail. So he needs to collect his 300 rupees per annum for maintaining the demat thing. That's all he's charging. And that is a very low price if you want to contain the control of your customer also. So that's why open a demat on FundExpert also. We have made an online process. That is. So basically we have made the entire ecosystem here only. If you want to open demat, open demat. You want to pre-manage withdrawal, you have to sell through demat only. So that is there is only one option. And obviously there is a process to do it demat. Yes, you can start demat for customers. Okay. AMC charges for demat is not free. Opening is free. AMC charges will be there, 300 rupees per annum. Whom we have tied up, the fulfillment partner right now is Composite, but we are also talking to other like-minded demat partners who will like make sure that these customers they will not target and all that. So we will have to every broking company has the mind of इनको free एक opening का पैसा दे दो and then take the customer and sell all the product. That's how everybody's mindset is. But I want people who don't want to do that. So I could only find Composite in the entire India so far. If I find someone also willing to, and Composite, I took a letter in the letterhead. If you don't know, there's a letter in the letterhead which we have printed that they will not do this. Because tomorrow I may say, how do you know he'll change? So I put in letter and give it to them. So that's why we have tied up with that. If you think there is someone who will never cross sell to your customers because you said now you don't want cross sell to your customers, then you need to go with the Composite for demat. But if you are fine with other demat companies cross selling, you can open with anyone and they will give you money also. No issue. Because after you're giving a customer to him, or he will sell other stuff to cross sell and he'll make his money. So now your choice what you want to do. Okay. So demat is chargeable because demat is a running service. He has to maintain record. You will purchase one capital gain bond and keep it for one sovereign gold bond, keep for 8 years. He is also incurring cost of keeping record. No, we can't do anything much, Rajendra ji. 300 rupees is not very high because that is the only fee which is coming out of that. Because every fee we have reduced it to almost there is no other fee for anything. That is the only fee left. If you ask me, what is left? Rest all is there. Even brokerage also giving 50% share back. There is nothing left. This 300 is the only cost. I checked up with them. They're saying this is the only earning left for it. Unless you want them to close. So we can't do it. So it is that the only choice we have. We don't have any choice. Okay. So that's all. It's 25 rupees a month, whatever you call it, but it's one demat. Okay. And then you can do that. So we can't do anything much. And for the guarantee that he will not do anything with your business. Comes with that guarantee. Your choice. I think 300 rupees is nothing. People, you just see account opening or charges for NPS. Or what is the brokerage charge? Now, here is one more thing. See, Composite is very flexible. They have given us free will, whatever brokerage we want to charge. So we told them we want the by default keep the lowest brokerage. So the brokerage at Composite by default is the lowest. But if you think that tomorrow you want because and share of that brokerage goes to you, and you think that you want to increase the brokerage charge to your customer, you can speak to us and we can make a customized brokerage for your client where we'll charge extra, but it will be shared 50-50. Otherwise, by default brokerage is the lowest in the country. It is lower than Zerodha, it is lower than Upstocks, it's 15 rupees per order. Yeah, I know people are coming to you for demat because they're opening LIC. I know a lot of demats have opened. I've seen in Composite also, outside also. Everybody is asking, I want a demat. You can open it in 2 days. In 2 days time, it's so simple and easy in opening in Composite. So you can open demat, or you have one more opportunity. You can sell the customer data to another broker by collecting referral charges. 2 options. Because then you are giving away the customer and they will be happy to pay you something for opening that. We don't, in our case, Composite, why Composite not paying you for opening demat? Because they are not going to market any service to them. We have bound their hands. So they are saying we will give you free. It is the only thing we can do because we are not going to do anything else. So, and then they can open LIC and they can buy all this kind of stuff. And 2 days time it opens. You start today and 2 days time you have the team. Okay. So I guess I have covered all questions, answered anything. I don't know anything. As usual, I have already exceeded all time. And I'm glad to see still a lot of you are still around. So I'll just stop sharing my screen and I don't know what. I have allowed you to unmute yourself. If you want to unmute yourself and ask anything which you have missed out, which I didn't cover, or somebody had any issues.
Hello.
One by one. So Vikram, I think you have spoken first because, or I will do one thing. I will unmute all. I'll do some. You can raise hand. Can you? Will that be easy? Because so I'll allow Vikram to unmute because I can see his hand. Vikram, you said something. You want to ask something? Quickly, yeah, we are run short of time. We already.
Yes, yes. Hello.
Yeah, Vikram.
Hello. Yes. सर मुझे बैकग्राउंड जो है ये मेक गुडविल का उसके बारे में थोड़ा जानना था क्योंकि उन एक सेकंड सर पूरा कुछ उन लोगों ने खुद ही अपनी वेबसाइट पे लिख लिया है कि हम कोई लॉ फर्म नहीं है
हाँ
वो
हाँ
एक सॉफ्टवेयर प्रोवाइडिंग ये है, अगर कुछ कॉम्प्लिकेशंस हुई और किसी लॉयर की जरूरत पड़ती है,
हाँ।
तो क्या लोकल लेवल पे उनके तरफ से या फंड
ऐसा
एक्सपर्ट की
कुछ
तरफ से
आपको
कोई
लॉयर
सपोर्ट
की जरूरत
मिलेगा?
पड़ती है तो आप हमेशा लोकल लेवल में अपने जान पहचान के लॉयर के पास जाएंगे, उनका रेफर किया लॉयर का आपको क्या
ओके।
जरूरत है। और वो डॉक्यूमेंट जो
ओके।
उन्होंने बनाया वो तो लीगली प्रूवन सिस्टम से बनाया हुआ है, तो वो डॉक्यूमेंट
ओके
आप
सर।
किसी भी लॉयर को आपको जाके दिखा लो, प्रूव कर लो कि देखो ये लीगली करेक्ट है कि नहीं, आपको इतना डाउट है।
ओके।
लेकिन ऑब्वियसली ये
ओके।
बहुत प्रॉपर और तरीके से बनाया हुआ है, इसलिए उन्होंने सॉफ्टवेयर बनाया। इसलिए क्योंकि
ओके
लीगल
सर।
एडवाइस के लिए बहुत सारा, अगर उन्होंने लिख देते लॉ फर्म है तो फिर आपसे वो लीगल क्लाइंट वाला जो एग्रीमेंट और कितनी सारी रिक्वायरमेंट हो जाती है, राइट। जैसे हो जाता है ना, आप
ओके।
एमएटी को जाए एडवाइजर लिख दो तो आपको कितनी प्रॉब्लम हो जाएगी। वैसे
सही
ही
सही।
उन्होंने वैसे लिख रखा है कि वो नहीं है, क्योंकि वो एक सॉफ्टवेयर है जो एक सही लॉयर नॉलेज से बनाया हुआ है। और ये उन्होंने जो आपके लिए है, ये इंडियन वर्जन है, इसमें इंडिया के हिसाब से चेंजेस हैं, ये इंडियन
ओके।
कंपोनेंट है, तो इंडिया के जो लीगल एक्सपर्ट्स हैं उसके हिसाब से ही बनाया। आप यूज करके देखो, आपको खुद समझ में आ जाएगा, हमने खुद देखा हुआ है ट्रायल और करके, आपको भी समझ।
सर, इट्स अवेलेबल ओनली इन इंग्लिश नाउ?
हाँ, अवेलेबल इन इंग्लिश टू टेक प्रिंट आउट, लेकिन जैसे उसने बोला ना,
ओके।
जो स्क्रीन में आ रही इन्फॉर्मेशन आप उसको गूगल ट्रांसलेट से आप स्क्रीनशॉट्स तो ले ही सकते हो, क्योंकि आपके पास तो पूरी
ओके
फिल्म है
सर।
तो आप ऐसे तो कर ही
ओके
सकते
सर।
हो। लेकिन वो फाइनल है, जैसे ये कंटेंट है, ये कंटेंट है, ऐसे। लेकिन आप उसको फाइनली गूगल ट्रांसलेट यूज कर सकते हो, ठीक है।
ओके, थैंक यू सर।
या थैंक। सन्मुख जी ने हाथ उठा लिया है तो अब उनको मैं अनम्यूट कर रहा हूँ। ये सन्मुख, ये मिस्टर सन्मुख, यू हैव अ क्वेश्चन क्विकली। आई डोंट थिंक सो एवरीबॉडी इज, देयर इज नो अदर क्वेश्चन। जल्दी से सन्मुख जी, यू हैव अ क्वेश्चन।
सर वो एक बार आपने वो चार्ज ले लिया बिल का, तो वो कितने दिन में, वो 30 दिन आप लिखे हुआ यहाँ है, तो वो 30 दिन
आप
में भी
टोकन का
एक्सपायर हो जाता है?
वैलिडिटी नहीं है, लेकिन कस्टमर जब बिल बनाना स्टार्ट कर देगा ना, वहां से
हम्म।
वैलिडिटी काउंट होती है, क्योंकि तब वो गुडविल सर्वर को पता चलता है कस्टमर ने अकाउंट बना लिया है, अब 30 डेज के
हम्म।
बिल। जब वो क्लिक
मतलब।
करके ये फॉर्म में, जैसे वो क्लिक करके यहाँ सबमिट करेगा ना कस्टमर,
हम्म।
तब से
हम्म।
30 डेज, और आपको दिखेगा पीछे कि उसका अकाउंट क्रिएट हो गया। सॉरी,
मतलब
वो मेरी स्क्रीन नहीं दिख रही होगी, मैं एक बार वापस स्क्रीन चेक कर लूँ।
पूरा सबमिट कर दिया, कर देगा तब तब भी वो, तब से 30 डेज।
हाँ, सबमिट कर देगा तब से 30 डेज, करेक्ट।
फिर बाद में मानो कि उन्होंने कुछ मतलब वो नहीं किया, डाउनलोड के पूरा नहीं किया, तो फिर
एक और टोकन उनको लेना पड़ेगा, आपके पास एक और सेल करने का ऑप्शन।
हाँ हाँ हाँ, ओके। और हमने टोकन ले लिया, तो ले लिया, और कोई कस्टमर ने कोई ऐसे सबमिट नहीं किया, तो जब तब 5 6 साल 10 साल भी चल सकता है?
हाँ हाँ हाँ, फिर वो टोकन वैलिड है, क्योंकि आपने टोकन उसका साइन किया, उसने जाके सबमिट ही नहीं किया है, तो थियोरेटिकली वो टोकन उसका खला पड़ा है, एम्प्टी है, यूज नहीं हुआ।
ओके।
ठीक है सनमुख जी, सो आई हैव टेकन योर क्वेश्चंस। अब आई थिंक आई हैव, अब मैंने जनरल अनम्यूट कर दिया है, बट आई डोंट थिंक सो किसी का क्वेश्चन बाकी है, किसी को कोई बोलना है, कोई पॉइंट है तो बोलिए,
Sir,
नहीं तो आई विल कंक्लूड।
sir, who is the our DMAT partner?
सन कौन पूछ रहे हैं?
Sir, you
राकेश
told me,
पांडे
but
जी।
explain. Yeah.
राकेश जी आप पूछ रहे हैं क्या?
जी जी।
आपका कौन है डीमैट पार्टनर?
हाँ जी, हाँ सर।
डीमैट, हमारा डीमैट पार्टनर है कंपोजिट इन्वेस्टमेंट्स प्राइवेट लिमिटेड, बैंगलोर का ब्रोकर है, 10,000 करोड़ पर डे का उसका टर्नओवर है एनएससी बेसिस। और वही एक ब्रोकर है जिसने वो अंडरटेकिंग राइटिंग में लिख के दी है। अगर वो कॉपी आपके पास लेटर देखना तो मांग लीजिएगा, आरएम से वो भेज देगा। ठीक है, ओके, तो सबके क्वेश्चन आंसर हो गए। कोई डाउट है तो आप अनम्यूट कर सकते हो, ठीक है, कोई डाउट नहीं है। वेरी गुड, सो आई लुक फॉरवर्ड टू योर कंप्लीट पार्टिसिपेशन इन दिस प्रोजेक्ट, इन दिस प्रोसेस, एंड टेक ऑल द बेनिफिट। आई होप ऑल यू हैड अ ग्रेट सेशन। हिंदी सपोर्ट नहीं है, हाँ, कोई कोई सब्जेक्ट में, करेक्ट, ये उनका कुछ वीकनेसेस है, वो हम लोग पूरी कर रहे हैं। जो कहीं हिंदी सपोर्ट किसी को चाहिए तो हम लोग के आर से पूरा कर रहे हैं, तो वो हम लोग मैनेज करेंगे, आई अंडरस्टैंड वो होता है। लेकिन हम उनसे भी बोलेंगे, ये हम ट्राई कर रहे हैं, तो फिर एक दो और ऑर्गेनाइजेशन से देखेंगे हिंदी सपोर्ट करके। Okay, thank you so much, and have a great evening. And you all stayed back and listened. Thank you so much.